All rise. The Court of Appeals Division 1 is now in session.
Good morning. Those of you, either one of you are wearing masks, so we're good. We're here for oral argument in NEPTUNE versus the City of Scottsdale. As you know, we record and live stream these proceedings, so please give your name and the name of your client when you begin. According to current protocol, you will each argue from your counsel table. You'll have 20 minutes. Although you do not need to use all of your time, we do require you to keep track of your own time on the clocks on the podium. They'll reflect your totals as we go. We recognize you may not be able to easily see them, so feel free to walk around to check your time, and I'll try to give you some signposts if you give me how much time you'd like to reserve. Please keep in mind we have read all of your briefing, we have studied the record, and we have already discussed your case in conference this morning. Counsel, you may proceed.
Thank you, Your Honor, and may it please the Court. I'd like to reserve 4 minutes for rebuttal. My name is John Riches. I'm joined by Lieutenant Hall. We represent Appellant Swing NEPTUNE Foundation. The City of Scottsdale defined a specific procurement process with specific and objective criteria. It then published that process to the public. It then established an independent panel to review the criteria that the city itself established. It then provided a mathematical score when it received 2 competitive proposals from that process. And when the city did not like
Counsel, you say that the city defined a procurement process. Can you point me to somewhere in the RFP itself that affirmatively states that this process is pursuant to the City of Scottsdale's procurement code?
Absolutely, Your Honor. That can be found at Appellate 5.1.011, paragraph 16, and Appellate 5.1.071, paragraph 10. The result of this entire process is that the city now allows the use of one of its most limited public resources, Olympics-sized swimming facilities, by one private entity at a rate that is far below market value. The city can enter into this sort of arrangement regarding public swimming pools. Nothing would prevent the city from entering into this sort of arrangement with the multiple other public resources it controls, from parks to libraries, airports, etc.
Let's talk for just a moment about on the gift clause analysis, the public purpose analysis. You, on behalf of NEPTUNE, are asking us to look at, as the trigger for that analysis, the cancellation, the decision to cancel or the cancellation of the RFP. The city contends that we look really more to the outcome of the process, which is this availability of competitive swimming opportunities. What is your legal authority that the specific thing we look to is the cancellation of the RFP as opposed to just the outcome of the whole process?
Your Honor, we know from both Turkin and Shires and several of the other gift clause cases that while public purpose is a permissive standard, frankly, the standard is whether the council unquestionably abused its discretion. And so if that's the standard for public purpose, when you look at what happened here, where the city set out its own criteria, evaluated proposals based on the criteria it set out, and then unilaterally canceled it when it didn't like the result that it received, that is an abuse of discretion. And we know that's the case from cases like Brown, where the city of Phoenix had frankly, a pretty similar situation where the airport had leasing space that was available. There was 2 bidders, one that had been done business with for quite some time, and they bid 18% of its revenues to use that space. And then another bidder, they bid 17%, and then another bidder bid 18%, and the city awarded it to the lower bidder. And of course, what the Supreme Court had said in that case is that's not permissible. That's an abuse of discretion. The city can't do this out of what's called a sense of loyalty when there are 2 equally qualified bidders. And I think that's a very important point in this case. There's no question there's 2 equally qualified, competent bidders. There's no dispute on that. Swim, NEPTUNE, and SAC are both qualified bidders. It's just that the city awarded it to its preferred vendor rather than to the highest, most advantageous.
So you're saying the public purpose is just the process? It's just the process of awarding, withdrawing, how you deal with contracts is the public purpose. So that isn't that a broader reading of public purpose than we can find in the case law?
Well, I don't necessarily Your Honor, because of the language that the case law uses, which is unquestionably abused its discretion. And if you step back and say, look, what's the purpose of the public purpose requirement? It's to ensure that public resources aren't allocated to private special interest use. And if a process can be perverted, if the process by which whatever the public purpose is to be achieved is the city has abused its discretion during that process.
So are you saying because of that prior case language, we have to look to the moment of the exercise of discretion in order to determine whether there was an abuse of discretion? Is that how you're applying?
I believe Your Honor, the court would look to the full record to determine whether or not under these facts there was an abuse of discretion, whether the city would question the abuse of discretion. And frankly, this record is a remarkable set of facts. It's quite similar to Brown, it's quite similar to Whitman, but pretty remarkable where a city has put out public bids, received them, scored them, and then said, you know what, we've changed our mind, we're going to cancel this whole process. If the city can do that, I mean, what's the purpose of public procurement, which is of course intended to protect taxpayers, just like the gift clause is. Additionally, though, we believe on the gift clause analysis, it's quite clear what the consideration requirements are, and it's quite clear that this arrangement fails the consideration requirements. So what the Supreme Court recently told us in Shires, and it had just reaffirmed 12 years gift clause case law, and even before that, is that the test is really simple when we're evaluating consideration. It's what is the government entity giving and what is the government entity receiving? And how do we evaluate the give and the get? The Shires Court tells us we must use objective fair market value. And what do we have in this arrangement? We have two bidders who are ready, willing, and able to pay for the use of these public resources. One offered to pay $439,000 per year. Another offered to pay $153,000.
Counsel, one of the difficulties here is that this is not a sort of a traditional gift clause case in that there's, the one in Shires, there's the one party and the government party, and there's a give and a get that's direct there. Here we have three parties. We have two offerors in the city coming back, and there's not the exchange of funds in the same way that there are expenditures in these other cases, gift clause cases. So I guess I'm finding it a little hard to properly apply the Shires analytical framework on consideration here. This isn't just money. There are also the other factors. For example, in the RFP, there's a list of factors that they evaluated. The fees were 30% or so, but there were other elements of the evaluation. So how do we take those into account? Do we take those into account in the consideration analysis?
Absolutely. To your first point, Your Honor, does the gift clause apply when we're not dealing with direct expenditure of taxpayer dollars? I think absolutely. We know that this court held in...
You can move past that. I agree that it applies, or assume that I agree that it applies. What I'm getting at is how do we properly analyze it when we don't have a traditional expenditure?
I see. Well, we think it's fairly simple in this case because all we got to determine, or all the court has to determine, is what's the objective or fair market value for use of these public facilities. And here we have two really strong pieces of evidence from the record that suggest what that is. The first was an open and competitive procurement process. One of the primary purposes of public procurement is to get fair market value for use of public resources when the city is going to fill out and receive services. Second, we know from the case law, what is fair market value? It's what a willing buyer and seller would arrive at in an arm's length transaction. Once again, that's what the that's what the public procurement process is intended to do. Turkin also suggests quite clearly that the possibility of a subsidy, the potential for a subsidy, is heightened in the absence of public procurement. Here, the situation is far worse. You had a public procurement, you had a most advantageous bidder, and then the city ignored it. So Turkin does instruct that the public procurement process can and should be used when evaluating things like objective fair market value. So there we have the give and the get, the value of the swim lanes. Can other factors be analyzed? Yes, and in fact, as the court noted, as Your Honor noted, they certainly were in this case. And Neptune was still the highest score, the highest mathematical score, based on all the factors that the city itself put in place.
Does the fact that there was less than 1 point between the two scores enter into this?
I don't think so, Your Honor. They were the mathematical winner. And I think it's also instructive to know what the city did after the procurement had closed and they'd announced an intent to award the contract. They published the results, at which point the mathematical error, prior to mathematical error being discovered, the city said, you know what, we've looked at this. The procurement process was done appropriately. It was done pursuant to code. It was done pursuant to the RFP. And SAC's the winner, based on our mathematical calculation. When the mathematical error was discovered and rescored, that should have been the same result. That was the city's position then. It should have been the city's position after the mathematical scores were redone, and it was determined that, in fact, Neptune was the mathematical winner of this. Whether it's half a point, 5 points, or 10 points, that was the result of the city's own procurement process. A couple other points I think are relevant for purposes of evaluating fair market value, Your Honor. The record is also clear if we're just trying to figure out, look, what do these lanes work? So what can we compare what Neptune offered, what SAC offered, to what this public resource is worth? We know from the record, and this is at Appellate 5, 1.127, that commercial users only paid $10 per short lane. Neptune offered 12. Now, the reason they offered 12 is because the $10 was set a little over a decade ago, and Neptune had adjusted it for inflation. But because the commercial rates are effectively in line with what Neptune offered, that is another strong piece of the record that suggests what the objective fair market value of these lanes are. And then there is no other. So then what does Shires tell us at this point? What is the government giving? What is the government receiving? Here, there is no other direct, legally obligatory promises that the city is receiving from SAC that it would not otherwise have received for Neptune. So the consideration analysis, in our view, is very straightforward. You have 438,000 versus 153,000. We know the objective fair market value from the bids. We know it from the prevailing commercial rates. That is grossly disproportionate under Shires, Turkin, in the gift cost case and all that precedes both of those cases.
In light of your desire to save some time, let's talk for a couple of minutes at least about the procurement code issue. I guess at the outset, what is our standard of review when we are approaching this procurement code issue?
Arbitrary and capricious or abuse of discretion, Your Honor.
Okay.
And admittedly, just like the public purpose requirement, now again, this does not apply to the consideration requirement, which the court reviews de novo, as we know from the Shires case. But just like the public purpose requirement, that is generally a permissive standard, of course, arbitrary and capricious. But once again, these facts are so extraordinary, we believe it plainly violates that process. We know that from Whitman. This court was very crystal clear in Whitman. And what the court said was that once a city has decided, the city has immense discretion to determine what factors it's going to use for a public procurement process. It can put in an enormous amount of information about what it wants to receive from proposals. But once it's done, once the city's exercised that discretion, once the city's received public proposals, once those proposals have been evaluated by an independent body, once the city has stated an intent to award a contract, at that point, the city's discretion ends, and it's purely ministerial, as the Whitman court said. There is no discretion. They have to award it at that point to the mathematical winner, or the highest, most advantageous bidder.
Under the procurement, Scottsdale's procurement code, so there's the notice of intent to award, and the code confirms that that's effectively an administrative award. It's been awarded administratively, but then there's the 7-day period that allows for protest, which occurred here. And your argument is once that period is over and the protests are dealt with, the city has no discretion but to award the contract to the winner. But the code allows for a protest. Doesn't the fact that the code allows for this protest suggest that there's a possibility of reevaluation or having to revisit something as the city tried to do here?
Conceivably, Your Honor, but then I think the question would be, what is being reconsidered? If they are going to reconsider, for example, a mathematical miscalculation, that should be permissible because they're not changing the evaluation criteria. But what the city tried to do here is change the evaluation criteria after those had already been considered. And that's where the abuse of discretion came in.
Weren't the presentations part of the criteria that the city said it could be?
The presentations are a very important piece of this. No, is the short answer. Not after the award has been made. So there's two points on this on the presentation piece. The first is that
but the award's been made, but as Judge Perkins said, there's been a protest, and so does that in essence rescind the intent to award and put them back in the same place that they were prior to giving that notice of intent to award, because you said that's an error, so they pull back, and you're saying that they're limited to only addressing what your protest was about, or do they get the chance to, since they haven't now, we've said they haven't actually issued a notice of intent to award at this point, why can't they go back to a reevaluation process?
I think they could, and I'm sorry if I wasn't clear in my prior answer. I think they could, so long as they didn't try to impose or add additional criteria that didn't otherwise exist. If there was an error.
But then we get to Judge Cruz's question, is that was a criteria that was presented to both parties that they could have presentations.
But the purpose, both in the code and in this specific RFP, and I can point the court to the record citations of presentations, was to inform the city about the proposals themselves in case there's any ambiguity about the proposals. So those presentations were supposed to be accepted prior to the evaluation, not after. The problem here is they tried to use the presentation after it had already been evaluated. And the only purpose of the presentations was to clarify the proposal so that an evaluation could occur. And that's where the abuse of discretion came in. And another important piece on the presentations, the RFP itself said that for the presentations, that they would have to let the parties know, hey, there's a date and time, you got to come and do this. That never happened. And the court below erred by saying that NEPTUNE unilaterally withdrew from the process. The city was obligated under this RFP and its own code to say, we're going to do presentations on this date and time. The city never did that. So as a factual matter, that never happened. Instead, the city unilaterally canceled the RFP.
You're at 3.5, I don't know if you wanted to reserve.
Thank you, Your Honor. I will reserve the balance of my time.
Thank you, Your Honor. Please the court, Eric Anderson on behalf of the city of Scottsdale. One of the things, and I think this panel, from the questioning I heard of opposing counsel, is struggling with, and the same thing the city struggled with all along since the 3+ years of litigation that's been going on, is what is the claim here? What is NEPTUNE asking this court to do? Are they asking for an injunction? Are they asking for mandamus? What are they challenging? We have a series of different events that occurred in here. We have a license that existed that the city had with the Scottsdale Aquatic Club in 2016 that was ongoing at the time of this procurement. That's the only thing. That's the only contract in existence. As it's been pointed out and undisputed, the RFP was canceled. So we have one thing. We have a gift clause assertion, and we have a procurement. Procurement is a process by which governments obtain goods or services or sell goods or services in this case. Gift clause is a separate analysis. The appellant hasn't provided this court with a single case that conflates the two of those arguments. And what the argument they're really advancing here is that, and they've tried to dance around a little bit, is that the city has to put everything out there for sale to the highest bidder. The case they...
Aren't they really saying if you put it out for a procurement process, you ought abide by that process?
Well, Your Honor, I think that's one argument they made, but when they failed to identify where the procurement process wasn't followed, then they switched to this gift clause argument. It's been this.
I'm sorry, where they failed to what?
Identify a problem with this procurement process. They haven't identified anything the city didn't follow. The procurement code the city has provided, and has been cited in the briefs, provides that the goal of the city in awarding in an RFP situation, request for proposal, not a straight bid process, is to get a consensus recommendation of the committee. It's not to count up points and see who's ahead by a fraction of a point. It's to get a consensus recommendation of the committee. City.
Did you say that that's exactly how the committee was supposed to come to a consensus recommendation, was by following the percentages of the factors that you laid out in the RFP?
Well,
So you can lay all of those things out, put out a request for proposal, say, here's exactly what you need to do. We're going to have 3 non-interested parties evaluated. We're going to have them show their work. And that's how we're reaching a consensus, but then change your mind when it's done?
Well, Your Honor, I have to disagree with the conclusion that the city simply changed its mind. What the record reflects and the undisputed facts reflect is the fact that when the acting procurement director looked at this, he discovered that there was an error in the process. And when the court reviewed Neptune's reply brief, they pointed out that the SCOTTSDALE Aquatic Club made a protest as well. And the basis they protested and pointed out was, hey, the committee should have scored these. It shouldn't have been this purchasing employee doing an arbitrary score number. That's exactly what the acting procurement director said in the undisputed testimony is, I looked at this, it wasn't done properly, it should have been scored entirely by the committee, not partially by the committee. And when he said that, he said, I'm going to send it back to the committee for that purpose. That's in our facts, and that's never been disputed. They don't want to address that. And the other thing they don't want to address, and they haven't addressed, is the Hertz Youth case out of Tucson that was literally a couple years after Brown, which they rely so heavily on, which Hertz Youth, serve yourself. I always struggle with that name. Hertz versus Tucson Airport Authority specifically said that absent a statutory requirement, there is no requirement that a city put everything out for a straight monetary bid. In the Brown case, which involved the city of Phoenix, there was a city charter provision that specifically required that to be put out for a quote, bid. And the irony too, if you look at the other case that they some of the bidding cases that are actually preference cases where people are asserting that the city should pay more because they are entitled to some preference, either residency or taxpayer type status or something like that. So that kind of is ironic to their argument that everything just has to be a straight monetary decision for the city. Hertz, you serve yourself makes clear that the city can put out a request and consider other factors than money. In fact, what also is in the record is that the procurement director that was concerned because the city council actually sets the fees, and those fees are based on, if you look at the SAC license, Scottsdale Aquatic Club from 2016.
So the city set the fees for that license, but doesn't the RFP, at least in part, suggest that there might be something different about the proposed new license? Because otherwise, why would you ask the parties to give a fee estimate and then weight it quite so heavily?
One thing where the city is prepared to stipulate is that the RFP was poorly drafted, Your Honor. And that's one of the reasons I think that led to the cancellation is the poor drafting of the RFP. But there's 2 provisions. Yes, Your Honor, it says what is your minimum bid for lanes. Then there's another provision that said your fees may be changed through the course of the license if they are changed through the program, which is the city council setting fees. The city had done this for years.
But reading those together, and we do have to construe your document against you as the city's representative, reading those 2 provisions together, doesn't that suggest you will bid for an amount per lane? That would be what your license is subject to, but recognize that that may change over time thereafter, not that you can give us an amount, but we'll probably ignore that and set our own fee. I mean, isn't the former a better reading of those two?
There's a minimum fee that's set forth at $4 and 8 hours for short course and long course. I think one reading could be that's the minimum, and if you bid that minimum, you might be subject to change. But that misses the point of that the monetary component of this was stated at 30% of the thing, which is entirely consistent with procurement law and the city's ability to decide and consider other non-monetary factors when it decides how it wants to allocate the leftover lane space in its pools after this.
I'm sorry, if this was confusing to me in the briefing as well, why would you have a 30% revenue line if you're saying that revenue would be equal between the parties because it's possible that the council is still setting the lane fee? That doesn't make any sense to me.
I have to confess that goes back to my previous stipulation that the RFP, I think, was poorly drafted and didn't set forth clearly. There was an intention. If you look at the RFP itself, it set the revenue at 30%. Then if you dig into what happened after the notice of intent to award, which I want to clarify that, because there's a distinct process. There's a notice of intent to award, and then there's a city council actual award. And if you look at cases not subject to, until that contract is actually made, there's no contract right. So intent to award is a distinguishable event between that and the city council actually awarding a contract. But Right.
But I'm still confused about why it would be a 30% weighted line item if you're answering Judge Perkins' question is to say that what they wrote and what they would pay was meaningless.
Well, that's not, and I don't want to say it's meaningless. I think it was weighted at 30%. The thing that led to when the new procurement or acting procurement director took over because of retirement, he examined that and he was concerned because that 30% was not 30% in the scoring. What it was done, it was arbitrarily by employees of the city that were in the purchasing department, arbitrarily assigned 5% to the committee and assigned 25% to...
I'm sorry, I don't mean to belabor this, but isn't that a different point? I mean, you're saying that the prices that they put per lane have no meaning because you anticipated that the council was still going to set the fees, but you're waiting at 30% in the RFP and it's affecting.
Let me explain, and I try to explain at least, because I understand your confusion, because it's certainly reasonable to be a little confused. It was set forth as 30%, and the committee was scoring. And if you look at the way the committee was scoring, they were scoring on 1, 2, 3, 4, and 5 based on that. If you look at the way it was arbitrarily changed by a purchasing employee, it was changed to the 5% was scored by the committee and 25% was scored. Why that's important in this case is because going back to one, you have the procurement code that says you have you're seeking consensus of the committee of what's in the best interest of the city, and you have a margin that is less than 1 point. That only reason that margin changed was because of the 25% that was not scored by the committee. What the acting purchasing director said is, I'm not comfortable because that factor was not scored properly, and that made, absent the monetary factor, if you leave...
So all of this that you're talking about goes to the post hoc discussion of the cancellation and the decision to make the cancellation. But I think Judge Bailey's point is on the gift clause, second prong of the analysis. If we're trying to figure out and correct me if I'm wrong about your point, but if we're trying to figure out the consideration question, or if we're looking to this valuation issue, how can the fee amount be meaningless or not driving when it was a significant and driving factor, at least initially, for the city when the city put together the RFP?
Yeah, and I want to go back to my opening and the confusion we've had, and I've asked to consider what is Neptune asking this, because what are they saying is a gift clause violation? Are they saying the cancellation of an RFP results in a gift clause violation? because there's no case that I'm aware of that says that canceling a contract results in a gift clause violation. That's the fundamental problem with this whole conflation of theories that they've engaged in since the trial court and continuing this through court is not a clear theory of what they're asking the court to do. A gift clause, their argument is that the lane fee that the city has is a violation of the gift clause because we'll pay more. The lane fees, as they stand, were set by the city council. So they needed to show that the fair market value of the lane fee at the time the city council set them resulted in a gift clause violation, not that they canceled procurement, because the remedy for a gift clause violation is the court to enjoin a contract. That's what happened. In Shears, the court invalidated the city of Peoria, I think it was, or Surprise, one or the other, their contract, that they invalidated. They didn't award a contract, they invalidated a contract, and that's why there's such a problem with this conflation of theories and a failure to really identify what is the gift clause violation.
Well, so the gift clause, our friends upstairs have been very clear repeatedly that the gift clause seeks to avoid using government resources to benefit or give special advantage to private interests. So isn't Neptune saying this cancellation of the RFP worked to give a special advantage to a private interest? And that is why the city canceled the RFP, because if it hadn't canceled the RFP, the winning bidder would have been the non-preferred entity. So the other points that you've made all go to whether or not there was a violation or whether or not there was a procurement code violation, but they don't speak to what is the challenge, which seems to be the overarching, this looks hinky.
Right.
You had a relationship with one entity. You thought that entity was going to win the bid. When it turned out that, at least according to the back and forth that we see in the record, the math was wrong, and when the math is corrected, somebody else was going to get the bid, and so we cut off the process. Like, that big picture is the articulated violation. The question of how we calculate consideration and everything tells us whether or not they're correct about the violation. That's not what is the violation.
Well,
Does that make sense?
I think it does, Your Honor. I think the point that they're asking you to skip over is the fact that the calculations were done improperly and were not consistent with the RFP because the purchasing employee arbitrarily pulled 25% out of that. So, and going back to the standard review, this court asked counsel, and he acknowledged, and I agree, that it's abuse of discretion. So you had every right to look at this RFP and say, well, we have two. We have Neptune Swimming, but we also have Scottsdale Aquatic Club, and both of them are entitled to a fair process. And what the facts show is that, yes, the city made a mistake. The purchasing department arbitrarily pulled out. That left it unfair to the SAC if the result is a 0.75 of a point.
Why is that unfair if you corrected the calculation? Why is that unfair to tax?
Because the RFP makes clear and the code provides that the committee will do the evaluation, not that there will be an arbitrary input.
But didn't you go back and correct that?
Well, the attempt was to correct it because the purchasing director said he was going to send it back to the committee because the committee should have scored the 30% in its entirety, not only 5%, because the RFP says it's the committee's job, not an arbitrary. That was the fundamental problem. That's why it's not fair to Scottsdale Aquatic Club or anyone. As they have stressed repeatedly, the city should follow its RFP. The RFP said it should be scored by the committee. The acting purchasing director said, well, this wasn't scored by the committee. It should have been scored by the committee. It's only 0.75. We clearly don't have a consensus recommendation of the committee because even with that scoring method, only one of 3 committee members actually favored Neptune. The other 2 did not.
Judge McCuish gave that explanation from Scottsdale in the summary judgment. The 5%, 30% discrepancy, or is that something?
I will confess not in the elaboration that I've provided. I did a better job in this court than I did it, but it was certainly there. It's certainly there in the statement of facts that the purchasing director looked at that and noticed anomalies in the way the thing was concerned, because it was a virtual tie, which we call, I know that's a matter of semantics, but it was less than 1 point. And we pointed, and the purchasing director pointed out that he wanted it sent back to the committee for evaluation and interviews to resolve that.
But the specific issue about the 5% and the 30% discrepancy was not something that Judge McKiddish had access to as a fact below. Is that true?
It was in the depths of the exhibits. I don't know that it was specifically pointed out or argued much in that respect at the summary judgment oral argument. The scoring the scoring sheets are in the statement of facts.
So the scoring sheets list the 5%. Did the evaluators have access to the RFP, which listed it at 30%?
The scoring committee, or
They weren't scoring that particular line item. You're saying they should have.
they scored.
That line item came from the procurement
The 30%, the point is, Your Honor, the 30% was stated as a single category of lapse in revenue, or lane hours in revenue. There was no distinction in the RFP whatsoever of 5 and 25. When it went somewhere in the process, the purchasing department changed it and only put 5% in the scoring matrix, which was part of the record in the court below, so they were certainly aware that it was only 5% of that was scored. It's not 5% is inaccurate. It's actually 1/6. So 30% was the total for the lane revenue. They split it up into 5% and 25%, and 25% was arbitrarily calculated. And I sense some confusion, Judge Perkins.
This feels like a helpful post hoc rationalization, but the evaluators' criteria then left open. It suggests that they were unaware that they were only taking into account 75%. I mean, I think if I understood Neptune's argument, it was the fact that this criteria said 5 and not 30 doesn't mean that the evaluators, doesn't it just mean that you multiply out their evaluation of that line item? Because otherwise there's 25% of their 100% pie missing.
Right. Well, no, Your Honor, that doesn't mean that, because if you multiplied that, simply use the numbers, the evaluation committee used a 1, 2, 3, a maximum of 5 points. If you take that as the evaluator's score and project that out to the 30%, Scottsdale Aquatic would have been the higher point total. Okay. The only way that Neptune got to the 3/4 of a point, which is probably closer to half if you round correctly, but it's fine, 3/4 of a point. The only way that Neptune got there was the 25% was arbitrarily removed by the purchasing department and done as a purely mathematical calculation. And the 5 points that the committee used was strictly done on the 5%. So that's clearly did not follow the RFP. That's why it's important that, going back to the city's discretion, we had a situation where the city has 2 competing swim teams. I don't understand, the public purpose argument, because they're both same thing. But clearly, they both had rights. It wasn't done properly. The city went back and tried to do it properly, and Neptune withdraw. I see I'm out of time. If I don't have any.
Thank you, Your Honor. Just a few points of clarification. First, as Judge Perkins pointed out, the purpose of the gift clause is twofold. It's to prevent the depletion of public treasury and to prevent the application of public resources for private special interests. This deal does both. The public treasury is being depleted to the tune of $284,000 a year for use of public resources. And this is clearly an award to a private special interest because of the course of dealing that previously occurred. The consideration analysis is not, is straightforward under Shires. What are we getting? What are we giving? The city asks, what is the gift clause violation? The gift clause violation is occurring as we sit here today, as the city is subsidizing, using taxpayer resources to subsidize one private entity. And of course, we sought declaratory relief as well as mandamus, and in a declaration that the city cannot give away public resources at a rate that is far below market value would certainly be appropriate. To this point about what happened when the procurement process was closed, I think there's two crucial documents in the record that I'd like to point the court's attention to. In APB 5 2.45, this is the intent to award. It's dated March 15th. And then in the very next page, APB 5 2.246, it was approved by the purchasing director on March 26th. And as you see on the approval signature, indicates file complete and final. At that point, the procurement was done and over. When the lead procurement director who had approval authority approved this contract. This did not need to go back to city council. This notion that, well, we got a new procurement director. The procurement was poorly drafted. That is all post hoc justification. It's precisely what this court in Whitman said we should not allow. It's precisely what the Supreme Court in Brown said we should not allow. The process is over. There was a mathematical winner. The city has conceded its mathematical violation, and that Neptune was, in fact, the mathematical winner. And that discretion ends at that point. A final point from the record on what the city is now, by the way, this is the first time that this 30%, 5% issue came up. This is yet another post hoc rationalization. The record is clear on this point as well. APV 5 1.114, that is the evaluation criteria. And there's no question that price was 30% of the evaluation criteria. That's where the mathematical error occurred. It was originally only given 5. The proposal said 30. When that was corrected, and the city admits that it was incorrect, when that was corrected, then there is no question that Neptune was the mathematical winner. To one final point in terms of relief, as I indicated, this is an action for declaratory relief. It's also an action for mandamus to put Neptune in the position it would have been in prior to the city's both gift clause violation and the cancellation of the procurement that it never should have canceled. And of course, this is an issue of statewide concern. If the city of Scottsdale can do this with public resources, here in this case with swimming pools, it can do it with any public resource anywhere throughout the country. If the gift clause means, or throughout the state, if the gift clause means anything, the procurement process means anything, it's to prevent that sort of outcome. Thank you.
Thank you. Thank you for your arguments. We'll take this under advisement and issue our decision in due course, and the court is adjourned.